Hi, everybody. Daniel Gaines here again. Time to go into a little more information. Full disclosure to y'all, this video and the next one may both run over the time. I'm going to try to keep them within the one video time limit, but they are probably going to be lengthy. We're going over declarations. Today, we're only going to go over Juliette's. This one, June 19th, 2015. All right. Starts early. She says the court records show that a return of service for the petition of dissolution and other documents, including a proposed parenting plan, was filed on January 20th, 2004. I notified Mr. Gaines that the dissolution was final, and his declaration attached to his motion for an ex parte restraining order states on page 4 of 8. She did file for it in 2004. However, there is no return of service. The first return of service that's filed, it's in May. I don't remember if it's 2004 or 2005, but that's the first one she can prove. So, on July 21st, 2004, Mr. Gaines signed a document purporting to allow Miss Parker's then husband, Brett Joshua Bussell, to adopt the child. The document states, I, Daniel E. Gaines, Daniel Eugene, understand that by signing this, I terminate my parental rights. The document also refers to modification of the parenting plan. Mr. Gaines was clearly aware of the parenting plan at that point. Now, that was after it was all finalized and everything else. I don't deny being aware of it at that point. I deny being properly served initially, which I never was. As far as the allegations of allowing my daughter to be adopted, it wasn't signing away my parental rights necessarily. It was allowing my daughter to be adopted. However, it was also an agreement that the parenting plan would be modified and I would get my daughter half the time. That's the only reason I agreed to it, because otherwise I was told by Juliette that I wouldn't get to see my daughter again. So I basically had no choice but to comply with her terms or not see my child again. But let's continue. However, the court document does provide my address at that time. She was married to Brett Bussell, living in Oklahoma at that time, and the document addresses her parents' address, not her address. Mr. Gaines states on page 3 of 8 of his motion declaration for restraining order that I was arrested for possession of an explosive device and reckless endangerment. He also states on page 6 of 8 that I was arrested and charged for selling and possessing military-grade ammunitions. These statements are false. Now, it's not that they're false. She was arrested for those things. Now, her charges ended up getting pled down, but that I'll get to in the same document, actually. But actually, her arrest and charges were what's stated in here, but she subsequently pled down. I was never arrested or convicted of the crimes he states. Not convicted, arrested. The truth is that my boyfriend and I had an incident in our home on January 18, 2014. We had brought some decayed ammunition that we found at a public lake near Joint Base Lewis McChord into our home with the intent of dismantling and disposing of it, and because of static electricity, some of the ammunition discharged, causing a small fire in the room above the room my son was sleeping in. It did not occur in the room our daughter was sleeping in. Now, in the restraining order hearing, I showed where she admitted that it was right above the room my daughter was in, and my daughter was in the room reading at the time it happened. Now in here, it's something completely different. My daughter wasn't in the room. Her son was in there sleeping, and it was a fire, not the explosive. Contradictory statements. This document signed under penalty of perjury. The other time she was under oath. Both of them conflicting stories. But let's continue. I will agree that it was not a good choice to attempt to disarm the ammunition, and I pled guilty to a misdemeanor of unlawful burning because of the accident. Yes, she took a plea deal and got it dropped down, got her charges reduced. Now, it's not that they was attempting to disarm the ammunition. The police report states they were breaking it down and selling it for scrap. She admits to breaking it down and selling it for scrap at the restraining order hearing. And again, that's in another video. Y'all have already seen that. Said, we moved to Texas after the accident to help my father with the care of my mother, who had recently had a stroke. I was unaware that any charges were being levied against me at that time, and I had been told that ATF had confirmed that the incident was an accident and there would be no charges. However, I learned later, in June 2014, that charges were being filed. Now, keep this in mind. Pardon me. June 2014, charges were being filed. My mother suffered a stroke at that time, and my father could not assist me financially with the costs associated with defending against the charges. He also needed me to assist with the care of my mother, so I agreed to a lesser charge rather than go to trial to defend against the charges. Again, keep that in mind. That's going to come back. And we go on. It says, it is in no way detrimental to the child's physical, mental, or emotional health, as Mr. Gaines has stated in the petition for modification adjustment to the parenting plan. So an explosive going off in the room above the room a child is in is not harmful at all to the child's physical, mental, or emotional health. Seems kind of odd, but let's continue. As per Mr. Gaines' report to CPS, an investigation was conducted, blah, blah, blah. He has returned a letter stating that the department does not have concerns regarding my ability to parent my children safely. That's actually factually incorrect, and I'll be showing the CPS letter tomorrow with my declarations to illustrate where, again, contradictory statement and evidence she provided attached to the same document. But anyway, under Section 2.11 of Mr. Gaines' petition to modification adjusting the parenting plan, Mr. Gaines states that the residential time of Mr. Gaines is not subject to limitations. However, the final parenting plan referenced above states under 2.1, father's residential time with the child shall be limited or restrained completely, blah, blah, blah. That's just all the legal crap that the original parenting plan stated. Although the part where it says the father will not allow mother visitation if the custody is granted, that's not, I don't know if that's in the original parenting plan, but that's just, I don't know where she got that. That's just something she claimed again, because I've never said that. I mean, I wanted 50-50. I just wanted to be a father to my kid. It does provide that residential time will be supervised every other Saturday. However, the issue is, when this was all done, we were residents of the state of Louisiana whenever she illegally filed everything in the state of Washington. And then afterwards, I moved back to my home state of Illinois, and getting out to Washington while trying to pay child support and everything else every other week, that's an impossibility, especially when minimum wage at the time was $5.15. Look it up, 2004 minimum wage in the state of Illinois. As for Mr. Gaines' assertion that he has never been notified of my location, I am attaching pictures of return receipts signed by Mr. Gaines of notices that I mailed to him notifying him of my relocation. Unfortunately, because of moving, I am unable to locate the actual receipts. I did not hear from Mr. Gaines and quite frankly believe that he was most likely deceased due to his drug use. He has not exercised his residential time with his child in over 8 years, with his daughter in over 8 years. Now, there's 3 to 5 things that have been the exhibits that she entered. Only the problem is there's a couple of them that are from restraining order attempts that I was actually served with. And before the 2015 order was entered, I can confirm and prove at least 12 moves. Now, she has maybe 3 where she claims they were address notifications. I can show 12. But yet, I chose not to be a part of my daughter's life. Something seems a bit off here. How can you be a part of somebody's life whenever you don't know where they're at? Anyway, Daniel's declaration states that I moved around numerous times just to avoid him serving me. However, I sent him certified return receipt letters with the court information of where I was located and a way for him to contact me if he wanted to set up a supervised visit with the court-appointed supervisor. Again, she wasn't always in the same state, and I didn't always know. as I just explained. But I'll get into that and show the proof. Additionally, my father has had the same phone number since 2008, and Daniel, of his own admittance, had no trouble contacting my father to locate me a few weeks ago. I had the same phone number for several years after Daniel stopped contacting me, and up to 1 year ago, when I changed service providers changed service providers because my prior service provider did not have adequate service in the area. Now, it took me calling her dad's work number like 30 times and telling him straight up I would not stop calling until he called me back to get him to call me back. That's difficult to get a hold of somebody or find out any information whenever he just refuses flat out to speak with you. But again, let's continue. Now, once has Daniel ever contacted me to set up any supervised visitations? Again, can't do it when you don't know where she's at. And it's hard to do it whenever she's not even in the state where the person who's supposed to supervise the visitations is at. Again, because of his failure to have contact with me for several years, I was not thinking about changing my phone number as affecting him. She didn't have the same phone number for several years, and I proved that in court too, but it was ignored because I am the father. Pardon me. It is true that I have relocated during the past 8 years. I have been married to a man in the military requiring relocations. In addition, I have a difficult and complicated pregnancy requiring care that my husband could not provide because of his obligation to the military. So I moved to be with my father for his care in Texas. Now, during the restraining order hearing, y'all heard her father say that up until 2009 at some point, he was living in New Mexico, or until 2010, whatever it was, he said that it was in New Mexico, which is after the time she's alleging here, which means the attorney letter that her attorney filed with the court of notice of withdrawal and intent to withdraw, because Juliette went to New Mexico and wasn't responding to her attorney anymore, has credibility, but yet here she's saying she went to Texas again. And then let's continue. It says, again, I did provide notice of many of the relocations. None of my relocations were done with the idea of hiding from Mr. Gaines or avoiding contact from him. He had been absent from our lives for several years. Now, many of my relocations, notified of many. 3 is not many. Even if it's 5, whenever it's 12, maybe even up to 15 moves, it's still not many. That's only a fraction. But when our daughter was 13 months old, she allowed me visitation at her home. I was giving her a bath and she bit me. He bit her back so hard that it left a mark and caused her to cry. I took pictures and sent it to my father, a physician. Notice there's no mention of a witness here, while during the restraining order hearing, a month before this, she said there was a witness. No mention of the witness now. And then now it left a mark and caused her to cry. Never before she said it caused her to cry. Her father's a physician, but she fails to mention that he's a pediatric gastroenterologist, not a primary care physician. But in October 2005, I became very ill and was eventually diagnosed with lymphoma. During the time, I regretfully allowed Daniel to take our daughter for a week. It was actually 2 weeks. When she returned to me, she had a horrible, severe diaper rash that was so bad that she bled. I took pictures and sent them to my father, a physician, asking for his advice. Well, she's never mentioned anything about pictures since then. It's never been bleeding or anything like that before this, and everything else, plus her father's statement's contradictory in and of itself. Now, my daughter didn't have a diaper rash as severe as she says. My daughter did have diaper rash issues when she was young. Juliette is very much aware of this. We used Boudreaux's butt paste down in Louisiana before we ever split up because my daughter had reflux severely and had a high acid content to her stools. Juliette's father even admitted to this and agreed to this before me and Juliette split up. He's the one that said it and recommended taking her to the doctor to have her looked at, and she ended up being put on Prilosec as a baby. She had Prilosec put in her diapers. She had Prilosec put in her bottles of formula before she was even 3 months old. That's how bad her reflux was. And I mean, it wasn't bad. There was actually just a little bit of redness to her diaper rash, but it was nothing ever that bad to where it was bleeding or anything else. There was times where it was pretty bad that it was a little bit blistered, but Juliette, that was even before me and Juliette split up, so Juliette's well aware of how bad her diaper rash could get. Now, before we split up, I was working a job where I was gone for 2 weeks and home for a week. And yeah, there were times I'd come home and our daughter would have pretty bad diaper rash, but I don't think it was because of neglect. I think it was just because of the fact that she had really bad reflux, and ever since she was a baby, that's just how things went for her. She was constantly having to use Boudreaux's butt paste. But anyway, in the fall and winter of 2008, Daniel made several telephone calls to me. He made numerous threats to me, including but not limited to various acts of violence, sending me a dead dog's head in the mail, having his friends follow me and beat me up and leave me for dead and take our child, come to my home and break in during the night and stomp my head until it stopped bleeding and take our child. Now, here's a few things I want to point out. Notice how follow me, beat me up, and leave me for dead. It's not in the restraining order attempts. It's not in any other statements at all except this one. And then come into the home and break in during the night and stomp her head. And that's never been said before either until this documents. Okay. She moved to California because I moved to California because my husband's duty station was changed in December 2008. I filed a restraining order and attempted to modify the parenting plan at that point in an effort to stop the threatening phone calls. He again called and threatened me with bodily injury, saying he would break my fucking jaw off. It's never been said before, but yet here it is in this document. The last time he saw our child was her 4th birthday in Texas. He was intoxicated and violent towards me. Now, whenever she mentioned the last time I seen our daughter during the restraining order hearing, she said I was threatening and had a witness, but yet no mention of a witness. The witness never made a statement, never came forward or anything like that. But now all of a sudden I was intoxicated whenever I wasn't a month before. But now a month later I was intoxicated. Kind of weird, right? The California court issued a temporary order for Daniel to call at 5 p.m. on Sundays. On the infrequent times that Daniel remembered to call on Sundays, our daughter would tell me she didn't want to talk to him and for me to tell him that for her. I told her she couldn't tell me that. She had to speak for herself and tell him that herself if that was what she wanted. And she did a few times. At other times, she would simply run away from the phone and hide in her room. I could not in good conscience attempt to force a 5-year-old to talk on the phone. I never refused to answer the phone or change numbers, and Daniel's phone calls were very inconsistent, infrequent, and eventually stopped altogether. Now, let's discuss this real quick. Court orders or court records from 2009 in Monterey County, California will show that she was getting griped at, I guess is a good way to put it, by the judge more and more each subsequent hearing for her refusal to answer the phone because I was submitting phone records and proof to the courts and everything else. It's all in the orders. It's there. It's Mason County has all the information we can clearly see in the order where the judge is getting more and more severe and strict with Juliette because she's refusing to comply. But then she says, I could not in good conscience attempt to force a 5-year-old to talk on the phone. You couldn't tell your daughter to get on the phone and talk to her father in good conscience. Doesn't that seem a bit off? Anyway, the only time he has seen his daughter in the last 11 and a half years is July 4th when she was July 2004 when she was a year old at my parents' house. August 2004, 13 months old at my house in Louisiana where he bit her. It's actually supposed to be August 2005. But anyway, October 2005 when he had her for a week and let her get bleeding diaper rash. Now, if I had her in August of 2005 when she was 13 months old and bit her and you were concerned for her safety, why was it that October of the same year you sent her to me for 2 weeks? Interesting. July 2007, the day before her 4th birthday at my apartment when he was intoxicated. He has had no physical contact with her otherwise, and he is a stranger. It was actually the day of her 4th birthday, and I wasn't drinking at all, and you made her sleep on the floor because she wanted something to eat after not even having one full slice of pizza that day. But then y'all can see that. It says, I deny all the other allegations contained in Mr. Gaines' motion and declarations. I by no means want to keep Daniel away from his daughter without just cause, and I am open to the possibility that people can change and better themselves. His girlfriend and her sister and mother have indicated that he is a different man. No, they didn't say I'm a different man. They said that they've never seen any kind of anything behavior-wise related to anything that closely resembles any of the claims and allegations she's made. But I'll get into their declarations at a later point. Hold on. It says, however, before he is trusted with the care of his child, even for minimal contact, I would ask the court that he be required to complete a drug and alcohol assessment, domestic violence assessment, and parenting classes. She has no problems letting me see our daughter, but yet I have to jump through all these hoops before I can even get any access to her. Seems contradictory in nature, doesn't it? Any contact with his daughter should be done in a manner that will cause the least amount of trauma for her. Any attempt at reunification should require a counselor present for such meetings. So you keep limitations on it to try and restrict and everything else. I am also asking that the courts deny the motion for a restraining order limiting my daughter's ability to be out of state of Washington. Mr. Gaines is not in Washington, and any temporary travel that she may be involved in over the summer to visit family in Texas would not negatively impact his ability to have contact with her, and her travel should not be restricted. Now, the problem is, it's 18th day of June. My daughter was sent to Texas in May 5th of 2005. Confirmed in court and everything else. So she's asking for permission to move after she's already moved. Now, the date on this is June 19th, less than a month after the restraining order hearing, okay? This one was filed July 6th, almost a month later. Amended declaration. Now, as you'll see, it's mostly the same. I want to make sure that it's all visible. That way nothing can be said. For the most part, there's a lot of the same information. But then here's where one of the differences are. If you notice on the other one, I wrote stroke lie on the side over here when she's talking about her mother having a stroke. If you recall, one second. Go figure. All right. Sorry about that. Now, June 2014. Keep that date in mind. Her mother suffered a stroke at the same time. Okay. June of 2014. We had moved to Texas after the accident to stay with my new boyfriend's family. I was unaware that any charges were being levied against me at that time, and I had been told that ATF had confirmed that the incident was an accident and there would be no charges. Before it was, they moved down there because her mother had a stroke. And then she moved back, and then at the time she learned of the charges, her mother had a stroke. So her mother had a stroke, she moved down there, and then when she learned of the charges, her mother had a stroke again. However, I learned later in June 2014 that charges were being filed. I returned to Washington. My mother suffered a stroke in October 2014, and my father could no longer assist me financially with the costs associated with defending against the charges. He also needed me to assist with the care of my mother, so I agreed to a lesser charge rather than go to trial to defend against the charges. So her mother had a stroke, causing her to move to Texas whenever she got in the criminal trouble in 2014. Then she learned of charges being levied against her in June of 2014. And her mother had a stroke then. And then her mother suffered a stroke in October of 2014. Something's off. Now, the error, she claims, is because of a paralegal. A paralegal made the errors, and that's why she had to file an amended declaration. Now, in this one where she says return receipt about the notifications, because she's moving, she's unable to locate the actual receipts. Convenient because they don't exist. She thought that she didn't hear from me because, quite frankly, she thought I was deceased due to my drug use. And then all of a sudden in this one, she received an email from a former girlfriend saying he was fired from his job for drug use. Notice how exhibits are all in these documents, but yet there's no exhibit for this. And there's never been a mention of this before. During the restraining order, she claimed that, or at one point, might have been a restraining order or hearing, but at one point she claimed I was fired from a job for drug use. But now she had an email from a girlfriend. I think it was, she said a girlfriend said something to her or called her or whatever, or she had a document from her. Now it's an email, blah, blah, blah. But that way everybody can see. Still the same document. But there is those changes, and the change of involving her mother having a stroke, that's not a minor change. That is something that is an accident. That's somebody not being forthcoming with the truth. I'm sorry, I don't care what anybody says, but that's just a fact. There's not an error that's going to be that big and you're going to read over and sign this document under penalty of perjury with that kind of a massive error in it whenever you're not trying to pull one over. The problem is she didn't expect me to have the information from her father's Facebook page showing when her mother had the stroke, because it was on his Facebook page and I was able to see the information, took screenshots and everything else before he blocked me. So, yeah, this one, July 6th, 2015, the very next day. Mr. Gaines does not have any relationship with our daughter. He has voluntarily removed himself from her life for over 6 years. He is a stranger to her. He claims I have hidden her from him and changed my phone number in an effort to elude him. This is not true. I am filing under separate cover documents showing that I've had the same number from July 2005 through July 2013 and only changed my number in 2013 to advantage of a lower cost plan. Now, the thing she submitted was an email just that showed that it was an email from T-Mobile. Didn't have a phone number, didn't confirm phone number, didn't deny phone number, blah, blah, blah. Nothing. He never exercised his residential time under that order, talking about the 2004 order. Now, if y'all remember, whenever I showed the CPS intake interview with Juliette, she claimed to CPS that I exercised the visit with our daughter one time, but yet in 2015, he never did, which I didn't actually go up there and do supervised visits. It was every other weekend. I couldn't afford it. I was paying almost $500 a month child support for one kid when minimum wage was $5.15 an hour. They was taking over half my damn check every month for child support. How can you afford to travel to Washington every other week under those circumstances and pay for visits? You can't. It's impossible. Especially whenever you're illegally served and have no say in anything, child support amount or anything else, and she's allowed to lie to the courts about income and such. But anyway, as for his motion for a temporary order restraining travel prior to the court's restraining order dated June 8, 2015, my daughter had traveled with her brother to visit her stepfather in Texas. It is the summer, and during this summer break, she is spending time with relatives out of the state of Washington. It would not be reasonable to require that her summer plans be changed at this point in any contact that the court would order with Mr. Gaines could take place where she is. Mr. Gaines is not in Washington, and any absence of the child does not negatively impact his ability to conduct court-ordered visitations. However, what she neglects to mention is how I sent certified mail to my daughter before this, trying to find out if that's where she was, and send her a notice and try to get her a birthday card. It was sent back due to the person she was claiming where my daughter was. That wasn't their address, I was told. So, but why is it that if my daughter went there, it was sent there for a summer break, as she says, why did she pull our daughter out of school on July 5th or May 5th of 2015 and send her out of state? Pulled her out of school early to send her out of state. Okay, she was sent out of state in May, was never brought back to the state of Washington. This one from September of 2008. Following is in support of my request to relocate with my child. She says, I didn't even mail my daughter a birthday card, refused to come visit her. I was never offered the chance to come visit her in 2015, where I was told she was, the address it was. I tried to send her a birthday card and a note, and the stuff was sent back saying that was not a good address. Saying I haven't bothered to visit and I had supervised visits for a reason. However, she neglected to mention that the reason was through default because her criminal activity in falsifying court documents, moving jurisdiction illegally to the state of Washington when jurisdiction was actually in the state of Louisiana. Now, she's talking about I was living with her for 12 years and I haven't had no contact for 8 years and only seen me 5 times. She was 5 months old. No relationship with me whatsoever. It would be extremely detrimental to her to disrupt contact between her and her mother and her little brother. There would be no disruption between her and Daniel, as there is zero contact between her and Daniel for more than half of her life. Due to parental alienation and malicious mother syndrome, yes, there has been no contact for most of her life. Daniel has supervised visitations for being abusive physically and mentally to both myself and our daughter and being neglectful to our daughter while caring for her. Yet, at the time that the 2004 order was entered, our daughter was under a year old. She was only like 5-6 months old. There was no allegations of any type of abuse to my daughter at all in those documents. The only allegation of abuse in those documents at all was that, as the restraining order hearing showed, that during an argument or something, I allegedly took a phone out of Juliette's hand. That's it. That's all the allegation was. But yet now, all of a sudden, in this document, it's because I was mentally and physically abusive to her and my daughter and neglectful to my daughter. No. She says she was moving to Texas to care for her sick mother and to be close to all her family and friends while she got treatment. Her mother, over a year or almost a year out from her stroke, had high quality care because of her dad being a doctor and having the means to afford the high quality care. Interesting, the school our daughter is now attending in Texas has test scores far above the national and state standards. I'm not going to read all of it, y'all can see it, but the school our daughter is now attending in Texas. Additionally, our daughter has been placed in several pre-AP classes at the school in Texas where she will be able to take her advanced reading and literature abilities and challenge them daily in the classroom. Admitting our daughter's already enrolled in school, pulled her out of school early for a summer visit, and then enrolled her in school for a summer visit. And then to show this, and as you see, there's that. Now, enrolled her in school and everything else, but this was in the request to relocate. So as you see, things aren't what they seem. There's clearly some lies going on. But to keep this video in one, I'm going to go ahead and end it here. I'll be back tomorrow with the next video showing my declarations. Thank y'all. Y'all have a wonderful night. Please watch and share. Have a good one.